doesn't include the application before the trial judge.
My Lord, it's an originating process.
Yes, but it's not a writ, as defined by the rules.
You see, my Lord, the word used is includes.
Now, would you say that the provisions in Order 55 are cognizable to the joinder and Order 4?
My Lord, the provisions
yes.
of Order 55.
Yes, because you see, by your own showing, Order 55 has prescribed means by which the court can hear a party whose interest will be affected. You understand?
Yes.
By service of the affidavit. So would you say that that provision, an application under Order 55, will recognize a joinder application under Order 4?
My Lord, it should. And my Lord, the reason is that, my Lord, with respect, the reason is that the rules on joinder,
yes,
unless there is a specific provision detailing how an originating process should be done differently other than Order 4, is applicable. And my Lord, if you look at the reasoning of the trial judge,
yes,
he did not reason that the application was brought pursuant to Order 4, for which reason he was not going to hear it.
I haven't said that.
So I'm just pointing out.
I was asking whether, given that Order 55 has prescribed the means by which the court may hear a party whose interest will be affected, there is a need to even call in Order 4, and whether Order 4 has legal basis.
My Lord, a quick response.
In a judicial review application.
My Lord, we notice that the issue of natural justice,
yes,
is a constitutional matter.
Yes.
And the rule cannot, as it were, defeat the intent of the Constitution. That to the extent that a person will be affected by a judicial decision, that person ought to be heard, yes, with or without the rule. And so the issue of the rule coming in aid, with the greatest respect, does not even arise. We are raising a fundamental question that relates to the rules of natural justice. It cannot be said that Order 4 or any other rule, if not complied with, satisfy the requirement of hearing. It cannot be the case, with the greatest respect. Okay. 2.
Yes, proceed.
In addition, my Lord, even without Order 4, my Lord, it is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, with the greatest respect, that was flatly ignored. And so, my Lord, the point we are making, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court. My Lord, should not, with the greatest respect, be endorsed, because the precedent will be dangerous as far as the rule of law is concerned. My Lord, 2.
How? In what sense will the precedent be dangerous?
No, my Lord, the point I'm making is where a party, in fact, maybe let me put it this way, 2 parties can actually collude and overreach a person who will be affected. And that precedent is dangerous. And in this specific case, when the application for Mandamus was moved, the judge asked counsel for the respondent, are you opposed? He says, no, I'm not opposed. No, I'm not saying so. My Lord, I will say so. My Lord, I will say so. But the point is that if this is allowed, that possibility is so grievous and present. And that is why this court must deprecate, with the greatest respect, that conduct.
Also pay attention to the affidavits in opposition, yes, and then the statement of case in opposition.
Very well.
address them.
My Lord, with the greatest respect, and I want to draw this court's attention to judicial review applications. Or judicial review applications. My Lords, exhibits attached to our judicial review. My Lord, we attach exhibits, that's the Republic versus High Court, Electoral Commission Respondent, National Democratic Congress. My Lord, it's in the supplement. Yes, so, my Lord, I'll be very specific. I have a supplement.
Is it a problem you have created for us? Some of the exhibits, I have them as B, and my other I have it as A or C. This is the problem you have created for us.
My Lord, I'm sorry. I'm sorry about that.
Unlike the other party who have actually flagged.
My Lord, that should be Exhibit D in our supplement. It's the application for judicial review by the NDC.
Yes, you make the point and let's see if it will help us locate
Okay,
the
okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him. In fact, I stood up. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you this application. So we even filed ours on the 16th. On the 16th of December. This Mandamus application was filed on the 17th. But my Lord chose to hear the Mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Oh, okay.
Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day.
Okay.
So I stood on my feet and drew my Lord's attention that, my Lord, these are declarations with video evidence. So consider my application first. He ignored it. And so, my Lord, with the greatest respect,
I lost respect.
Yes, Counsel.
You see, some of the facts being heard on this court are indeed erroneous. Yeah, erroneous. And I think it's fair that I put them in context.
Okay.
The process he filed.
Counsel, you can raise
No,
this.
just
Please,
hold on.
Please. What he filed was not before the judge. It was not before the judge. It was not on the docket. We were not saying.
No, it may not be on that
She
docket.
was listed.
It may not be on that docket, but it may be in a separate docket.
No, Manos. He came to court holding the documents.
No, we're talking about the second application. Or the one
What is the application?
The first application, the one they filed on 16th.
The one they filed.
On 16th.
Yes, that was determined by the court on the same day. Yes.
Okay.
That's
No, that's just
the
the
joint
one.
that he had filed.
No, we're talking about the first application. Okay. So, Mr. Tamaklo,
Yes.
continue.
So, my Lord, at the time my Lord considered the Mandamus application, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the Mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it, and started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared. And that at the time he was considering the Mandamus, he knew that that would definitely affect their rights. My Lord, on the grounds of bias, on the grounds of bias, my Lord, the point we make here is that at the time, with respect, my Lord was considering the Mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he is done hearing, our application for judicial review would have become moot. Manifest bias. My Lord, 2. The Mandamus application, in one breath, my Lord says, our gender, on page 2, offense order 20, rule 14 of CI 47. However, my lords, the Mandamus application that was granted, with respect, had no statement of case attached. So in one breath, my Lord was holding us to the strict compliance of the rule, but in the other breath, waive it for the interested party. My Lord, without the statement of case, the court's jurisdiction for the Mandamus was not properly even invoked. And so the orders founded on it were definitely done in excess of the court's powers or its jurisdiction. We submit.
What is your authority for saying that?
My Lord, Order 55 Rule 6. 2.
It says what?
6.2. The court may, on the hearing of an application for judicial review, then 2, within 14 days after the filing of the notice of application, the applicant shall file such numbers, such copies of the applicant's statement of case. Mandatory. And my lords, this court, in the case of My Lord, in the case of Ni, because my Lord said what the authority.
Of course.
Yes, yes. My Lord, in the case of Ni Okaija the third, and Ni Tete Ahinkwa the second, and Thomas Okai, civil appeal number J4, 2009, dated 29th April 2010. His Lordship Justice Badegbe had this to say, that when J4/20/2009, it was dated 29th April 2010. It says, quote, where the rules of court prescribe a particular mode of seeking relief, then a failure to initiate the proceeding for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Now, in excess of jurisdiction, specific. In the case of Francis Owusu-Mensah and another, versus National Board for Professional and Technical Examination, civil appeal number J4/57/2017, dated 1st May 2018. It was held 57. Eniegba JSC, as it then was, had this to say: a court may have jurisdiction to entertain a cause or matter, but the procedure invoking its jurisdiction may deny the court's jurisdiction. In this case, the court, the High Court, has the jurisdiction to entertain a Mandamus application, but the rule says, at the hearing, a statement of case must be attached to the application. That is how the court jurisdiction is invoked.
Mr. Damaklu,
My Lord.
even in this court, your colleague raised a fundamental issue, preliminary objection, which we have waived.
Oh, my Lord, I take it that you are
He has
willing to
raised
waive
it,
this one.
and we said that, look,
No,
we
my
are
Lord,
waiving it.
no, my Lord, when you waived, it was on record as having waived it.
So it's,
In this case, my Lord, the ruling of my Lord is before you. The court never said they are waiving that non-compliance. My Lord, the court never said that. It is a different thing if the court, in exercising its powers, gave an indication on record that it is waiving that non-compliance. That was not done. My Lord, it's a court of record. Yes. My Lord,
But does it matter to you that the other side did not file an affidavit in opposition? Does it matter to you
yes, my Lord,
that the EC before the High Court was not opposed to the application?
my Lord,
Therefore, the waiver even started with the EC.
No, my Lord, the waiver is not one that the party should raise, with the greatest respect. It's not one that requires that a party should raise an objection to the non-compliance.
Party may raise it.
Yes, I'm saying that without that, this court is required to consider it.
Yes.
Yes, my Lord, what we are basically saying is to just draw this court's attention to the nature of the bias. That in one breath, he holds us strictly to the rule. And my Lord, that is even denied. The joinder application had a certificate of exhibit with the greatest respect attached to it. Yeah. Yes, yes, yes. not on prayer, there was no exhibit. Yes. So, my Lord, I'll just read the ruling.
Oh, no. Which one? On your non-compliance with the rules?
No, the issue of the manifest bias.
Okay.
My Lord, Exhibit B series, Ex-Parte are not on prayer.
Yes.
My Lord, there was no exhibit attached. So the issue of certificate of exhibit does not even arise. But my Lord said we had offended the rule.
Okay.
My Lord, 2. Ex-Parte Nana Ekwia Owusu Efriye. That one, we attached a video recording of the declaration. And there is a certificate of exhibit attached. But my Lord simply says he is applying the ruling mutatis mutandis. My Lord, I want to bring to your attention the decision of this court in the Republic versus High Court Bogatanga. Ex-Parte Hawa Yakubu, 2001-2002 Supreme Court of Ghana Law Report at page 553, sorry. The Supreme Court had the occasion to quash the orders of the High Court in Bolga because the court said, Hawa Yakubu, who had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said she had the right to be heard, and that right was breached. And all the orders made by the High Court in Bolga were quashed. And the resulting effect that all the consequential orders, having been founded on those orders, must collapse with it. My Lord, the affidavit in opposition filed by the first filed by the Electoral Commission. The position made is that because
proceed.
Because the applicant parties, at the time the application was heard, they deserve no rights, or there's no issue of breach of the rules of natural justice. My Lord, that is completely far-fetched. Because the application for judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or if he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. The EC knew. And that is exactly the decision of the Supreme Court in Ex-Parte Hawa Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission, deposed to by Mr. Samuel Tete, be expunged from the records of this court.
Why?
My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituencies named.
I think he preceded his affidavit by stating that within his knowledge and information, didn't he?
My Lord, the point we are making is that, with the greatest respect, my Lord,
Yes.
one, he does not attach any official record or official document to the deposition, or a police report by any of the returning officers detailing the so-called
Yes, so
of fraud.
that weakens the weight.
Very well.
I don't think we...
No, my Lord, I just want to bring it to you
Okay.
that those depositions should not be recorded to.
Oh, no, we said that, the man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter.
Very
But you can't, you don't say we should expunge it.
My Lord,
Yeah.
the respondents say they had already done the collation. And so what is the point, you considering our application? My Lord, the morning of that Friday, with the greatest respect, I had appeared at General Jurisdiction 6 with my learned senior Justin Amenufo and Gary Nimaku, where there was a pending injunction application against the Electoral Commission. That it, my Lord,
My Lord, so far, various applications have been made in this court in the course of submissions which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel, if he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the needful. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel.
Mr. Tamago,
Yes.
We have a...
please restrict yourself to your affidavit and let's go on.
Yeah.
yes, my Lord. So,
We don't
my
have
Lord,
the whole
no,
day.
my Lord. So our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us Tuesday.
My Lord, this is not before the court.
Okay. So you haven't deposed...
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My Lord,
You were addressing us on what you said is the argument that
Yes.
the declaration has been done already. So address
my
us.
Lord, our quick response is that, in fact, in the Hawa Yakubu decision, orders were made, and those orders were even complied with. But when it was brought to the attention of the Supreme Court that there was a fundamental breach of the rules of natural justice, the decision and all the consequential orders founded on it were all set aside. My Lord, it is on this basis that we make this prayer. Yeah, so, my Lord, it's on this basis that we invite this honorable court we urge on this honorable court to quash the orders of the High Court General Jurisdiction 13, my Lord, maybe just a quick point. In paragraph, my Lord, with respect, in paragraph 10 of the 2nd to 7th interested party affidavit in opposition, particularly paragraph 10, it is deposed to the fact that our agenda was heard.
Yeah, that's their case.
That our agenda was heard and dismissed.
Yes.
My Lord, with the greatest respect, the gender application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
The problem I'm complaining about, what you are alleging, my Lord, is not captured in affidavit.
Is that paragraph what?
To the paragraph where you said the joinder was heard. A joinder which was on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. I'm saying that we were not heard.
So it's different from saying that the
Very
joinder
well.
was
We were not heard. My Lord, nowhere in my Lord's ruling did he hear a say, with respect, that he heard our agenda and dismissed it. Nowhere. In fact, he himself said he will not allow the agenda to affect the quick hearing of the application. How can that same agenda be deemed to have been heard?
No, he said he gave you a hearing on the application.
Yes, my Lord, and that is what we are
So it's not the joinder. He had before him an application for Mandamus. And their case is that when you appeared, he heard you on the application for Mandamus.
No, my Lord.
No, I'm trying to get you to understand their case because you are misrepresenting their case.
Very well. So, my Lord, the point we are making is that we were never heard on the application for Mandamus.
Mr. Tomekulu,
Because first we were praying that we'll first be joined, then we'll be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My Lord, 1 minute.
Yes, I have it as A series. The one in respect of Nana Akua Owusu, a 3 year.
My Lord, I want to just locate my...
I believe it's yours as a B series.
Okay.
No.
Okay. Yes,
You found that?
yeah. Is it the Mandamus application?
Yes, the ruling, yes.
And the ruling, oh, okay, we attach it to our supplement. That's the B series.
Yes, I have it as A series, but it's fine. But the one in respect of Nana Akua Owusu, a 3 year.
Yes.
Have you seen the ruling?
Yes.
Please read the first paragraph of that ruling. It's in connection with whether or not you were heard.
So,
Can you read it?
yes, the application of on the face of it is not different and notwithstanding the submission of a friend of the court in the person of Godwin Kuju Edwiji Tamaklo to the effect that the winner of this constituency has been declared, and he proceeds, which no evidence is before the court, except an application yet to be moved.
Yes.
Yes.
So you made a submission.
No, the submission is to draw his attention of the pending and the judicial review. And notwithstanding bringing to his notice. In fact, he described me as a friend. A friend of the court. At that point, I was not counsel for a party.
No, but you were not, you were not a party to the application.
That's
Perhaps that was why he decided to describe you as such. Yes.
No, my lord should see representation. You see that there is no record of me being a representative. See, counsel. Oh, my lord, just to draw his attention.
Anyway, we still have two other lawyers here. So,
my lord,
you wind up.
My lord, on this basis, so, my lord, this court has on many occasions upheld the fact that a person to be affected by an order or a decision should be heard. My lord, within this context, a failure to do that, my lord, will be a serious affront. That affront to the rule of law, constitutional requirements, and the right to head the other party. The Supreme Court, and my lord, I conclude here. The Republic versus Court of Appeal, Anthony Tomford, Ex-Parte Ghana Chartered Institution of Bankers, 2011. 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Atibuba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the Odi Atheron Parting Rule involved. That Odi Atheron Parting Rule has been elevated to constitutional pedestal, and this breach has constitutional consequence. My lord, and said breaches void the act in question. My lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Mr. Justin Amenuvo, counsel for the first interested party. Can we hear you?
Yes, my lords. My lords, we are opposed to this application and rely on our affidavit in opposition and the statement of case in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, not a single one of them, has deposed to an affidavit in this court telling the court what injury they have suffered by General Decision 13 just saying that Electoral Commission, go and perform and complete your constitutional duty. None.
the individual applicants?
Yes, my lord. There's none before you. They have not deposed to any affidavit.
How about the first applicant?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. It's an official person. These are individuals. The first applicant will not go to parliament. It are individuals. They are before you. They have not said anything. My lord, well, he said he has sponsored. Let the sponsoree, it's the sponsorees who go into parliament, not the sponsorer. My lord, the second point I'm making is that I will refer the court to the case of Bobier versus 21st Century Construction Limited. And now the civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my lord presiding and his brother, now retired Justice Badegbe, delivered the ruling, and their ruling touched on the effect of Order 5, Rule 1. Order, my lord, with respect, Order 4, Rule 5.1. And with your kind permission, if I may read. Of CI 47, my lords. No proceedings shall be defeated by reason of misjoinder or non-joinder of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
But it was not a writ. Why do you
no, that's why I use the word even if. Even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action is one of appeal. So far, in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore, Cesurera should lie. Respectfully submitted. Thank you.
Oh, counsel. But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No. My lord, the order in Hawa Yakubu was directed at her. An injunction placed. But in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder. But you can question it on other parties.
Yes, my lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my lord. And then also, one last thing, now that you have brought it up, my lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my lord will look at it as an application. My lord, there is an application because of the way the numbering is manual. I'm not able to